any
Right.
camera or anything. Well, first of all, thank you for doing this. I look forward to this for some time.
Well, it's my pleasure, and it's part of the fun of receiving this beautiful award.
Well, that's something. Well, let's just start with that. What did you think in a life filled with many awards and honoraria and the like? What did you think when you found out that you had been nominated to become a laureate of the Lincoln Academy?
Well, I was surprised. I had no idea that this would happen. I was honored, of course. I was flattered by it because of the persons of achievement and excellence who have received this award in the past. They've all been distinguished men and women, and certainly it was a great privilege for me to have my name added to theirs. But it came as a complete surprise. I never imagined that I would receive this honor along with the wonderful people who've received it in the past and are receiving it now.
You're in wonderful company. Couldn't be beat, I'm sure.
No question about that. They picked the best. Of course, also it caused you to wonder, how in the world did I get in with that class of people?
Well, I think that's what we're here to talk about, actually. You come from a family that I suppose is steeped in legal traditions. Your father was a lawyer. How did you become attracted to a life in the law?
Well, I was a debater in high school. I dabbled a little bit in high school politics at Roosevelt High School on the northwest side of Chicago. I pronounce it Roosevelt rather than Roosevelt because it was named after Teddy. And I saw one of my classmates recently at a dinner, and I mentioned Roosevelt High School, and she cautioned me it was not Roosevelt, it was Roosevelt in the days we went there. So I was attracted to that, and then I went to Northwestern University, and I pretty much had made up my mind by that time that I wanted to go to law school, and I debated again at Northwestern, and took courses in political science from some very famous professors, and just went naturally. Also, I grew up in the tradition, too, of watching Clarence Darrow. I was fascinated by his defense of the Loeb-Leopold case, and then the Scopes trial in Tennessee. I was a youngster then. Those are things that fascinated me.
Why would a figure like Clarence Darrow have such a strong influence on a young person like yourself?
Because he was defending people who were underdogs, and he had this great charisma about him. He attracted all the public attention, and he seemed such a real figure, such a figure that you could relate to. I never saw him, by the way. I wish I had tried to, but I didn't.
He was a monumental figure in the early 20th century in legal circles. Were there other prominent attorneys or other attorneys who may not have been prominent per se, but who were influential upon you?
Well, I don't think so. That was primarily the person I attached to.
You said something about you liked the fact he was fighting for the underdog. Your career also, the things I've read of it, has a lot of that in it too. You work a lot for people who are under the gun, literally, in a lot of cases.
Well, I have actually, before I became a judge. A lot of my practice was in the antitrust field, and I was, for the most part, representing smaller businesses that were being suppressed and restrained by larger businesses. So I felt during the years of my practice that I was working for the underdog, those who were behind trying to catch up.
A lot of those were in the motion picture business. You did a lot of work in that. Can you tell me a little bit about what those cases were about?
Well, in the 1920s and 1930s, the arrangement that developed in the motion picture business was that the producers of 5 big studios became owners of theaters, and particularly in the large cities, but in the small towns too. Right here in Springfield, there were the theaters were owned by the large chains by 20th Century Fox here in Springfield, and the studios used to exchange their pictures with the other theaters. In other words, 20th Century Fox had the theaters here in Springfield. They got the pictures of Paramount, and in return, 20th Century Fox would license their pictures on the earlier runs to the Paramount theaters in Chicago. And an independent who wasn't connected with that studio exhibition setup had no chance of getting pictures until the affiliated theaters were through showing them. And of course, the cream of the motion picture exhibition business is in showing the pictures early.
What were you able to do for the small independent theater owner?
Well, I was able to get them money for having been suppressed for a long while, and I was able to get them the opportunity to compete, to bid for the early run of pictures. And perhaps the greatest contribution I made, it would have happened anyway, but I was one of the earliest people preaching the idea that pictures didn't have to be shown downtown first, particularly in the big cities, that it would be better to put the pictures out in the neighborhoods where it would be more convenient for people to see them. Well, today, you know, that happens all over. There are no theaters left downtown. They're all out in the malls and the neighborhoods. So I was talking that way 45, 50 years ago. I was a little bit ahead of my time.
Now, I'm going to depart a little bit from the law because I want to talk about your life in public service. A lot of folks really may not know it, but it begins with Chicago City Council and the Cook County Board. A lot of important work done back there. When did you first get on the Chicago City Council?
1955, May of 1955.
What would you say were some of your most satisfying accomplishments there with the council?
Well, I had something to do with censorship. I opposed the Motion Picture Censorship Board, not because I had been representing theaters, but I felt that was improper censorship. That was a board which reviewed all pictures before they could be shown in Chicago to see if they were fit to be seen not by children but by adults. And that, of course, was improper censorship. That was a satisfying thing. I attempted to hold down the budgets. I was a skinflint always, and when I was in government, I was the same way with the county board. I was successful in holding down that budget pretty well. I tried to hold down the charges that were made by the city-owned garages in the Loop, and I did it at some discomfort personally, because the night in the city council that we were debating whether the rates in the city-owned garages should go up, I had made a visit to all of the larger garages in the city, and I insisted we take them one by one And as we took them, I got up and said I was there. The decks were filthy. They were full of grease. And I said, I went to this other garage. I went in the toilets. They smelled. They were awful. And all my objections were overridden by the majority that the mayor controlled. And then after it was over, I went to the Sheraton Hotel in Chicago to pick up my wife, who'd been there at a dinner. And we went downstairs to the garage in the building to get our car. And we waited a long while, and all of a sudden I said, where's our car? And the attendant said, get my car, and he took me down below the lower level of Michigan Boulevard. I'd never been down there. It's like catacombs. There are 2 or 3 levels under the lower level of Michigan Boulevard. And we were driving around. He said, look, you see your car? And I said, no, I don't see it. So he finally said, your car was stolen. I said, how come my car had been stolen out of here? He said, it wasn't here. I said, it wasn't here. Where was it? He said it was in the city-owned garage on Rush Street. There were 6 cars stolen out of that garage tonight. I said, my goodness, that proves my point, how incompetently these garages are being operated. So the next morning, newspapers picked it up, and television, it was all over television. It was ironic that here, while I was in city council arguing that these garages were being poorly run, inefficiently run, my car was stolen out of one of them where it didn't even belong in the first place. So next morning I went to see the street commissioner to see what he was going to do about my stolen car. He locked me out of his office, and I was pounding on his door to get in. They wouldn't open the door for me. There were television cameras that saw that. And the next day the mayor canceled the increases in the rates in the garages. Now that's having to go pretty far to make your point, isn't it?
Yeah. But you made it. That's great. You were also on the county board?
I was on the county board I was there for about 6 months, and then the president of the board, John Duffy, died, and I was made president. And then I ran for the office. A few months later, in the election of November 1962, I was elected, and I served 4 years as elected president of the Cook County Board of Commissioners.
What stands out about that time in your career?
Well, as I say, I try to keep down the budget. I expanded the forest preserve. One thing that stands out in the story is 1 year, as we were in the budget, the head of the Cook County School of Nursing, this was a school that recruited high school students to teach them to be nurses, and at the same time they were unpaid help for the hospital, sort of assistant nurses. That was a way of getting help cheap at the hospital. But the head of the hospital had an item in her budget, a large item, for travel expense. And being a skinflint, I said, well, what do you need all this travel expense for? She said, we need it to go out to Nebraska, Iowa, Dakotas, to Missouri to recruit nursing students. So I said, why do you want to go out there? Why don't you go right around the corner to Crane High School? You can walk there and recruit the students from there. And she said, well, you don't understand, Mr. President. Those girls don't fit our standards. Well, this was mostly a black school, black students. And I said, don't fit their standards. Have you tried? I said, if I were the father of the valedictorian or the salutatorian of the Crane High School class or the Marshall High School class, you told me my daughter didn't fit your standards, I'd be pretty mad. I'd start questioning you. And I think we ought to do something to recruit the students from Chicago's inner city schools to this School of Nursing. Well, you'd think I said kill every patient at County Hospital. The people rose up in wrath against me. They said, how dare you try to lower the standards of the hospital? And then I pointed out to them that we had a lot of Filipino nurses, we had a lot of black nurses at the hospital, but where had they been trained? They'd been trained in nursing schools in the South in America, nursing schools in the Philippines. And I said, I bet if you look at those schools, they're not schools that meet your standards either, and yet their graduates are working in your hospital. You're very delighted to have them. Well, there was a lot of discussion about it, and we finally set up a preparatory course for students from inner city schools who wanted to be nurses and wanted to get into Cook County Hospital. And I thought that was an accomplishment. And I think I called attention to a problem that existed that should not have existed. It was a set of mind that was wrong and that had to be exposed.
Exactly. When did you come to the bench?
In 1974, I was elected to the Illinois Appellate Court.
And any cases come to mind there that...
Well, you know, it was interesting how I got there. I'd been sort of a maverick in the Democratic Party in Cook County. Although I was an official member of it, I was a ward committeeman of the 40th Ward on the northwest side. And I developed it, I take credit for it, I developed it into a very strong voting Democratic ward in the 10 years or so that I had been commissioner, 14 years. And I thought it was time to move out of the council. It was getting a little too old to keep screaming there in the council about things. So I wanted to be a candidate for the appellate court, and I came before the Democratic Party screening committee, and one committeeman said, well, what if we're not able to slate you? What will you do? I said, I'll run anyway. I'll run independently because I think we need independence in our reviewing courts. And to my surprise, I was slated. Of course, 6 years later, when I wanted to be a member of the Supreme Court and there was a vacancy, I did have to run independently.
You came to the Supreme Court 6 years later, was it?
In 1980, yes.
There are a lot of different cases there that come to mind. Many of them, though, in particular, deal with the death penalty. First of all, what are your feelings on the death penalty, so we can get that out?
My feelings are that it doesn't work. It's chancy. The chance of anyone being given a death penalty is just as chancy as Justice Potter Stewart, when he was U.S. Supreme Court judge, said, just as chancy as being struck by lightning. And Justice Blackmun, after supporting the death penalty all his career, as he was about to leave the bench, said in a dissent, I've changed my mind. I can no longer support the death penalty because it doesn't work. It cannot be fairly and evenly imposed because it's being imposed by people and it's being imposed subjectively. And that's the only way you can impose it. You can't have a death penalty that says everyone who commits murder, regardless of the circumstances, is going to be executed. You have to do it on an individual basis. Once you start doing it on an individual basis, it cannot be carried out fairly. And not only is the death penalty chancy, but what is even more frightening is that the discovery of whether people are innocent or guilty after they've had the death penalty imposed is also so chancy. Take the Cruz case, for example. The chance there that changed the whole complexion of the thing was that there was an election of new Supreme Court judges. The last time that Cruz was up before this court, the court had already affirmed the conviction and the death sentence by a 4-3 vote. And then there was a petition for rehearing. And had an election not intervened, I'm sure the petition would have been denied 4-3, and Cruz would not have had that last trial that proved that the sheriffs had not been truthful and that he was innocent. But there was an election, 2 new judges came on the court, and the 4-3 for conviction turned out 4-3 for a new trial. I'd say that was a chance. Another chancy thing was in the case of the defendants who came to be known as the Fort Heights Four. Williams was the one who had the death sentence imposed. The others who were convicted with him of a brutal murder of a gas station attendant and his girlfriend in one of the southern suburbs of Cook County were here before the Supreme Court. And Justice Underwood wrote an opinion, again affirming the conviction and the death sentence. There was a petition for rehearing. And I'm sure the petition for rehearing would have been denied. Incidentally, I dissented when the case first came before the court. I dissented because I felt that Williams had not received effective assistance of counsel, that his lawyer had not done a very good job for him. And the Constitution gives every defendant the right to counsel, the Constitution of the United States, the Constitution of the State of Illinois. Well, while this petition for rehearing was pending in the Williams case, we had an argument out here in this courtroom on a lawyer who was up for disbarment. And his name was Archie Weston, and he'd been a lawyer of some distinction. He was an African American, and he'd been president of the National African American Lawyers Association. And here he's up for disbarment. But the record showed that when his case was heard before the commission that initiates disbarment proceedings, he never appeared. He wasn't there. And here he is in the Supreme Court saying he shouldn't be disbarred. So I said, Mr. Weston, I want to ask you a question. Why didn't you appear before the commission and tell them your case? And he said, I was too stressed out. I was broke. I was financially strapped. I just couldn't think straight, and that's why I didn't appear. Well, when we got back in the conference room here, I said to my colleagues, look, I believe that this is a lawyer who is defending Williams, and I believe he was defending him at his trial at the very time that he said he was stressed out and couldn't think straight. And we checked into it, and sure enough, that was right. So much to Justice Underwood's credit, he then threw his first opinion in the wastebasket and wrote a new opinion saying that Williams and his colleague, his co-defendants, did not have effective assistance of counsel. They were given a new trial. Now, what if that coincidence, that fortuitous circumstance of Archie Weston having been here at that time hadn't happened? Goodness knows what would have happened to Williams. What if there hadn't been that election in the Cruz case, bringing 2 new justices on the court? Cruz might never have gotten a new trial. Maybe a federal court would have seen differently, but you can't be sure. And I could cite other cases where just by chance there were things developed which showed that the defendant was not guilty or that there were mitigating circumstances. And that's why I say who gets executed is too chancy to put up with a death system.
There were some other things that we talked about. talked about the Constitution. If I forgot the quote, if I have the quote right, my obligation was to uphold the Constitution, not the veneer that other judges have placed upon it.
That is true. I think that the obligation of each reviewing court judge is to the Constitution itself. And that's developed in the law. There are countless cases of where decisions involving constitutional interpretation and constitutional application have been overruled, some by almost the same judges that decided them in the first place. Many instances where new judges come to a court and say that the first decision was an erroneous interpretation or application of the Constitution, and they must be reversed. And that's why I say that the Constitution is our guide, our government, both our federal and state constitution. They're the supreme law of the land, they're the supreme law of this state, and each judge should have more attachment to the documents themselves and to the opinions that have been written by previous judges saying what those judges think the provisions of the Constitutions mean. And that's something I argued all along in connection with the death penalty cases. Some of my colleagues kept saying that they had to stand by the death penalty in Illinois because of stare decisis precedent. And I kept saying, that's wrong. Precedent has no standing when you come to what the Constitution means.
Well, it also goes to something else you told me about the law not being a static thing, because the society changes. There are things that well, we change opinions on things. Could you elucidate on that a bit?
Well, I believe that all of law requires change when it no longer serves the needs of society or no longer protects society, when different applications of law are required to serve the needs of society, and that's true even of the common law. The only place where I think precedent should govern is where you're interpreting statutes, because those are enacted by a legislature, and often they're ambiguous. It's pretty tough to understand really what the words mean, so courts have to interpret them. But since these are creatures of the legislature, the statutes, if the legislature doesn't like the interpretation the court has given, they can change the statute and reword it. And I did that incidentally. I saved some trees. The State Department of Conservation was going to log trees in the state forest, permit private logging companies to come in and log the trees. And they said that that was necessary in order to have proper growth of the forest. And I took the position, I was supported by my colleagues, I took the position that the forests were to be natural preserves, and let them be with what they are. And if the forests get overgrown, once in a while fire comes, and fire is a natural thing for a forest to clean it out. And I said that as I look at the statute setting up our natural forests in the state, they were not to permit logging. And I said, now, I may be wrong about the way I interpret the statute, but if I don't interpret it that way, the trees are going to be gone. No one will know whether I was right or wrong. So I think we ought to preserve the trees, and if the legislature thinks that that decision is an improper application of the statute, let them change the statute. Well, the trees, I think, are still there.
You're a conservationist, too.
I am.
What are your feelings on that issue, about conservation and the importance preserving natural resources?
Well, this country's going to last, hopefully, for a long, long time. And if you use it up, if you use up the water and foul up the air and contaminate the forests, you're not going to have a country that will last for 1,000 or 2,000 years, and hopefully the United States of America will.
Back to the law for a moment again. You also told me that the courts ought to be in the lead in the efforts for justice. You told me as we were, having a discussion on the phone about your philosophy in the law, that the courts ought to be leading the effort to justice and equality. What serves as the basis for that thinking on your part?
First, the Constitution of the United States, which guarantees equal protection to all citizens. And second, I think the needs of a democratic society. No question about the fact that there has been inequality in the United States among the citizens. Best example of why erroneous interpretations of the Constitution have to be changed is segregated education. Plessy versus Ferguson decided in the 19th century, which said segregated schools were okay as long as they were equal, and they never were equal, was a wrong decision. And much to the credit of the law and the Supreme Court of the United States in Brown versus Board of Education, came too late. It should have come many years earlier. That doctrine was changed. And there are many other places in this country where there was inequality, and that inequality should be eradicated both by the courts, by the legislatures, by religions, by civic people, by good-minded people. The courts can't do the job themselves, but certainly Brown versus Board of Education and cases like it have gone a long way toward eliminating discrimination and inequality in this land.
Would that be one of the things that's given you the most satisfaction in being in the law, is to work for those values?
Indeed.
Tell me about that.
Well, it's thrilling to see discrimination, inequality eliminated, and it's important because this country cannot continue to be strong if a large part of its citizenry is not well educated, does not have equal opportunity for jobs, for housing, for health, for hospitals, for physicians, for life.
Is that one of the things that's given you the most satisfaction in your career?
Yes, yes. But I wouldn't say that I've been able to do a lot for it. I've done a little bit, but certainly not with Thurman, not with Thurgood Marshall, not with William Brennan, not what Justice Blackmun have been able to do.
A couple of other areas that we need to talk about. You played a role in World War II in the Navy, in the South Pacific and the island hopping campaigns that went on. You were in the logistical area.
Right. Well, it was in the Central Pacific when after the Japanese air power in the Pacific was substantially diminished, the Navy reverted to the plan it had. This was a traditional plan going back maybe 75 years for war against Japan, which was to put all of the services and supplies for the fleet on ships. and move those ships right along with the fleet as it advanced toward Japan. And the Navy called it the train. But after Pearl Harbor, the Navy was so devastated, and the control of the air was so shaky that they couldn't take a chance of putting supplies on ships, so they started building these great naval bases ashore in the South Pacific at Noumea, Espiritu Santo. But the trouble with those was they no sooner got them built than the fleet was operating 800, 1,000 miles ahead of the base, and they were almost obsolete. So when we started across the Central Pacific and took the Marshall and Gilbert Islands, the decision was made to put all the services on ships, and I was the first officer that the commander of that flotilla had. But the Navy still didn't have real confidence in that plan, so when we went into the Marshall Islands, they planned to put a service detachment at Majuro to serve a few ships. And then what happened? We knocked over a truck, and we found that there was no Japanese air closer than Guam and Saipan. So the decision was made to leave all of the big fleet, the carriers, the big cruisers. There weren't so many battleships yet. They came a little later. They were back still being repaired. But to leave them all out there, and overnight we became a more important supply base than Pearl Harbor was. And my commanding officer was made like the governor of the atoll, senior officer present for administration. And it really was a pretty exciting time, because between every fleet operation, the fleet would come back, and I'd see all the famous admirals at close hand. I saw Spruance and Halsey, Turner, Mitcher. I saw Nimitz, too. Occasionally he'd be out there.
That gave you you were telling me earlier that gave you an awfully good head for detail and what was needed in terms of planning things.
Yes, well, it did, because I was the flag secretary, and I was planning all the operation plans. I wasn't planning them, but I had the job of seeing that once they were planned and put on paper, that they got out and got distributed to everyone. I've had a lot of detail there, and a lot of hours. We used to work almost around the clock.
How did that help you in your professional career, an opportunity like that?
Well, I suppose it made me pretty good on discovery. On discovery, you're involved in a lot of details and a lot of paper and a lot of facts, so at least it helped me in that way. But I was inspired by my commanding officer, Worrell R. Carter, Annapolis, class of 1907. And he was a very, very inspiring person, a very diligent person. He had a lot of honor, great integrity, and he was one of the inspirations of my life.
I want to also talk about the Martin.
Incidentally, he was born on a sailing ship. His father was a master of a sailing ship that was going between Boston and San Francisco, and his mother was on the ship, and he was born on the ship.
It doesn't get much better than that for a Navy tradition. Oh, man. Martinsville. That was now. Was that after you were off the court?
After I was off the court.
Tell me about that experience.
That was in 1990. That was a big experience, too. That was very big. And I kind of fell into it. There's a problem of what to do with atomic waste. It's a problem all over the country. And there are two kinds of waste. There's the big stuff, the heavy stuff, which is really dangerous. And then there's light radioactive waste, which is clothes that were contaminated by being in contact with the heavy nuclear stuff, stuff that comes from nuclear medicine, stuff that just gets contaminated with low-level, they call it low-level radioactive waste. So the Congress of the United States, at the request of the governors, passed a legislative scheme to allow each state or group of states combined to set up low-level radioactive waste facilities in various places in the country. And they said by a certain time, every state or group of states was to have one of these facilities. Well, that time has long since passed. It's supposed to be 85 to start, and then 90, 95. There isn't one of those facilities yet operating anywhere except in Barnwell, South Carolina, which had it before this legislation was passed. Anyway, here in Illinois, the Department of Nuclear Energy went to work to try to establish this kind of a facility. And I think the director at the time had the idea that he'd be the first in the country to have that kind of facility, and that would be a feather in his cap. And so he kind of pushed things to get this done. But the problem was the statute in the state which provided for setting this up said it couldn't be set up where any county government, where not county, but where any government that had authority objected. Well, the places that they decided on for this facility were all in unincorporated areas that were governed by the county boards. And there were 10 or 12 places that were selected as good places, but one after another the county boards said, no, we don't want them. So under the statute, they couldn't set them up there. And the last big hope was Clark County, which is in the central eastern part of the state on the Wabash River, opposite Terre Haute, Indiana. And everyone thought the county board of Clark County was going to okay a site, which there was in that county. And at the last moment, the county board of Clark County turned it down. So there was no site. But the mayor of Martinsville came along and said, I got a plan. The municipality had authority over the area of a mile and a half from the municipality. So the mayor of Martinsville said, why don't you take this site within a mile and a half of Martinsville, and I'll get the city council to okay it when we don't need the county board approval. So the city council had a meeting at 6:30 one morning, 6:30 a.m. They approved it, and the Department of Nuclear Energy was then off and running. Well, this was a site that really hadn't been considered until that time. It wasn't a prime site. And the people in Martinsville, most of the people started objecting, and they were afraid of nuclear waste, as everyone is all over the country, and they started demonstrating they didn't want it. So Governor Thompson, taking note of all the disorder that was going on there, called me and said, I'd like you to be a hearing officer and go down to Martinsville and hold a hearing and see whether it's all right, whether it's safe. And he said, if you say it's not safe, we won't have it at Martinsville. And I said, okay. Well, when I started saying, when do we hold the hearing, the Department of Nuclear Safety said, well, we're not quite ready to propose this site officially, but go ahead and hold the hearing anyway. So I said, no, I'm not going to do it, because I don't want to say it's okay, it's all right, and then have you say, well, we've changed our minds, it's not satisfactory, we're not going to propose it. That leaves the governor and me on a limb. So months went by, and finally the legislature held a hearing down in Clark County on what was going on. They asked me to come down there, and they said, asked me how I got into that situation. I told them what I just told you, And then they said, do you think you're the proper person to do it? And I said, no. I said, I'm just an ad hoc creature of the governor. I have no authority to take testimony under an oath. I have no authority to subpoena witnesses. I'm just like a sounding board. What you ought to do is establish a commission, have a legislatively established commission to hold a hearing on it with subpoena power, with authority to administer oaths. Well, they did it. They established a 3-member commission, and then Governor Thompson appointed me chairman. And I then went down to Martinsville with my 2 colleagues, and I told the people, now look, there have been some disorders here, but let's stop all the disorder. We're going to have a public hearing. Every part of the hearing will be here in Martinsville. It didn't happen to be. We could have held it here in Springfield or in Champaign in Chicago. But I said, no, we're going to hold it right here where all the people of Martinsville can see and hear what's going on. And I promise you that before the hearing is over, everyone who wants to speak on this issue, every citizen, will be heard. Well, we then embarked on a hearing. I didn't think it would last as long as it did. It lasted 72 days. And why? Because before the hearing started, I said, you know, this isn't going to be a hearing unless there's opposition with counsel who can tell us what's wrong with this. Now, if the opponents don't have counsel, we'll just sit here as commissioners, we'll listen. The Department of Nuclear Energy will have all these experts, all these scientists in here saying this is okay, this is fine, this is good. And how are we going to challenge it? I said, we've got to make arrangements for the objectors to have counsel. So I then got the state to allocate $150,000 for counsel to be selected, and then everyone wanted to use the money. The proponents wanted to use the money too, and we decided, well, let's put it to the League of Women Voters. Let the League of Women Voters decide who should get the money. And thankfully, the League of Women Voters said the people who were objecting should get the money. And then they hired 2 lawyers who proved to be brilliant, one from Ottawa, one from Crystal Lake. And I was a little concerned at first that they hadn't hired big-time Chicago lawyers. But these fellows were great on cross-examination and on going down into the boreholes. There were hundreds of boreholes by that time on this land right outside Martinsville, and they were great at analyzing every piece of sand that had come out of those boreholes. Well, we started out with the scientists getting up there and giving us sort of a tutorial, a lecture on what was happening, and then these lawyers took over and started a cross-examination, and boy, that was a grilling. But they were terrific in tearing these scientists apart. And after the second or third scientist had gone through that, you could see that when they got up to start testifying, they weren't as confident as the first 1 or 2 who had thought that they'd give a lecture and this would be over in a few days. And these lawyers went at it, and it was a completely open and public hearing, and anything went, and we didn't restrict the examination very much or the testimony. Every aspect of this property was gone into, and it took 72 days, not 72 consecutive days, but stretched over a period of almost a year. And it was always down in Martinsville on the main street. We started in the high school auditorium, and most of the hearings, though, were in the American Legion Hall, Main Street, Martinsville, Illinois, population 1,150 people. That was an experience. You know, there weren't hotels or motels that were could house us in Clark County, so we stayed at Terre Haute at the Larry Bird Boston Connection Hotel, Larry Bird played basketball there at Indiana State University, and we used to drive 30 miles to Martinsville each morning. And that was an experience, and it showed me, the lesson I took from it is that where there's a public issue, it's good that the public is involved in. It's good to have a complete, open, public airing of it. Because when you get a clash of opinions, diversity of thought, that's the way you arrive at the truth. Well, after 72 days, we turned it down. It was really mushy land. It was wet land. It was surrounded by water. And everyone knows when you're dealing with nuclear stuff, you want to keep it dry. You don't want to take a chance of contaminating it. And we held a danger of contaminating the water supply of Martinsville and other cities in Clark County.
I remember I was in the news business. Well, I was the news director of the radio station at Carbondale when all that was going on, and I remember hearing all the reports on that, and ultimately it was a good call all the way around.
Maybe the people of Carbondale would have wished that we had okayed it in Martinsville, because if not, maybe they would have been next. Now, incidentally, then after that, there was a commission set up by the legislature to try to find a site. They haven't found a site yet. And as I say, everyone's been busy all over the country trying to establish these things, and there's a lot of money in it for people who are able to operate these radioactive waste facilities, but there hasn't been a one of them that yet has been in operation. And the big one, of course, that you hear a lot of publicity about is the one at Ward Valley in California, in the desert there, and there's an argument about that because the opponents say there's a danger that it'll contaminate the Colorado River 25 miles away.
Well, that's a possibility, I guess.
No, that I don't know. That I don't know.
What are you doing?
But we were worried about contaminating the water supply a mile and a half away.
Now that's a problem. What are you doing these days?
Well, I'm practicing law. And, sometimes it's a little dull. I've had a lot of high-profile activity in my life, and you can't have that all the time. So you get a little spoiled when you've been in Martinsville, when you've been on the Supreme Court. You're in a high a lot of the time, and there are lows too that come along. But you're working. A lot of things I do are humdrum. Although, right now, when I leave here, I'm going to New York. And I'm going to argue a case before the United States Court of Appeals for the Second Circuit, and that's exciting. I've never argued there. I've had cases in the United States District Court for the Southern District of New York, but never in the Court of Appeals there. So that's rather exciting.
One final question that I have. Let's let the train do its thing here. Okay. Well, what I was.
Well, I got a reputation as a jogging judge. I don't jog much now, but people still think I'm a jogging judge.
A familiar sight around Springfield jogging.
Yeah.
Ralph Dunn, a senator from down our way, was always out walking in the area. Yeah. If I recall right.
No, it used to be fun though. I'd run through Washington Park. People would, hey, Judge, how are you?
Well, I think people like their. I think people like their public officials to be accessible. You know.
Yeah. Oh, they do, sure, yeah. And they should be. Public officials should be accessible. I always had my telephone number in the phone book, and aldermen used to complain. People called them at all hours of the day and night. Actually, I don't think that happened too much. I very seldom was bothered by late calls, and when I did get late calls, they were people who were justified in calling me. But there are very few crank calls or silly calls that I ever received. My number's still in the phone book.
One of the things that strikes me about you is as you talk about your life and you talk about the law in particular, and this country, you strike me as very much an optimist about things. Why is that?
Well, what I'm going to say when I receive this award is that I had a great job, greatest job of my life, in the summer of 1933, when I was 17 years old, between my sophomore and junior years at Northwestern. I got a job as a guide on a sightseeing bus, a Gray Line sightseeing bus, at the Century of Progress Exposition. And that was a great record-breaking event, and thousands of people poured into Chicago each week from all over the country. Many of them came on excursion trains and buses to see the Century of Progress. And here I showed off Chicago by day, by night. We worked 7 days a week, and it was a very exciting job. But this was in the midst of the Depression, that all these people were still coming to Chicago to see the Century of Progress. And it showed me that the people of our nation have courage, strength, vitality, and optimism. And it were those qualities that carried us through the Depression. It was those qualities that permitted us to revive after that terrible day of infamy at Pearl Harbor. And after the war, it's those same qualities that helped us attack many of the evils that there are in this country, such as racism, such as inequality, such as lack of proper education. And I think we've made great strides, not enough, but we're moving. And that's why I'm an optimist. I'm an optimist from the time I saw people come to Chicago in the midst of the Depression to see the Century of Progress. Those were optimistic people.
Thank you.
Okay.
That was exactly what I was looking for. What a wonderful way to wrap
All right.
up. Thank you.